be seated. The final case in our docket is Charleston Builders versus Coastal Builders. Who's here for this one?
Good morning. May it please the court, my name is Sam Taylor. I represent the appellants Charleston Builders and Living Tag. I'd like to reserve 3 minutes for rebuttal, please. This case simply involves the Florida UCC and doors which the appellee Coastal Door Window, well referred to as Coastal, delivered to a condominium development for the appellants. During the course of performance, appellants rejected, refused, and returned some of the doors provided by Coastal, who in turn accepted, replaced, and disposed of the rejected doors with no objection, no reservation of rights, and no other words of limitation. At trial, Coastal, through its sole owner, David Miller, testified the doors were returned and accepted by Coastal were not defective. However, he admitted he never informed appellants of this situation and proceeded to put on a products liability case. The resulting appeal is on the final judgment entered on that basis. The position is the trial court erred by not requiring Coastal to prove it protested the appellant's return of the doors. During the course of business, Coastal willingly accepted doors sent back to it by the appellants, never protesting appellants' rejections nor reserving any rights to later question those objections. Under Florida's Uniform Commercial Code, a party must explicitly reserve its rights when a party performs or promises performance or assents to performance in a manner demanded or offered by that party.
Counsel, did you raise what I call the protest argument under 671-207 below?
Well, Judge, we didn't directly say 671.207, but the testimony that we were attempting to elicit, and in which the case that we put on is nobody ever told us these doors were not defective. The way the business progressed is the doors came out, we said, we think there's a problem here, take it back. They agreed to take them back and never said anything else about it.
What was your defense at trial?
The defense at trial is that we do owe you for the doors that you delivered, but not for the doors that you picked back up.
Well, I'm just looking at your answer here, and there's no affirmative defense of non-conforming goods or breach of implied warranty or any of that sort of thing.
That's right, Your Honor.
Was payment the only issue at trial?
Pardon me, Your Honor?
Wasn't payment or the only issue at trial?
Yes, Your Honor. That's what we perceived as it was going to be, is there was only payment. But the reason why we don't even get to the breach of implied warranties or anything like that, because they picked them back up. They took the doors. They didn't say we'll take them back under dispute, we'll take them back subject to us to testing them to determine or anything. They said, okay, we'll take them back up and we'll make it right.
But under the UCC, as I understand it, the trial court here found as a matter of fact that the actions of your client constituted acceptance under the UCC. So you've got a case where you have acceptance. In that case, your client has the right to revoke that acceptance if the goods are non-conforming. And that looks like, if you're trying to fit these facts under the UCC, that's what occurred here. But
well,
the UCC placed the burden on the buyer to establish non-conformity if they're going to revoke acceptance.
Okay, good point. And the reason why this is such a strange issue is typically what happens in the course of business, let's say you make the product your own. In this instance, you install the doors, you painted them, and you sanded them, and you discover a defect. What's the normal course of business? You notify the company that sold you the doors, and you say, we've got a problem here, we think we've got a defect. And in the normal course of business, what typically happens then is somebody either comes out and looks at the doors and says, well, I don't know if it's really a defect or not. Or the second alternative, we go hire somebody, do all this expensive testing, say the doors are defective, and then send the doors back to them saying it's defective. Neither one of those scenarios happened here. And in fact, this is the reason why it's different. In this scenario, we said we've got a defect. Mark the doors for pickup, and the other party picked them up. If they didn't accept the fact that they were not defective, then they should have told somebody. What that does is it allows a business person to lay in the weeds, if you will. We'll retake possession of those doors. We're not going to tell you that they're not defective, whether they're defective or not. We're going to take them back from you. We're going to send you no doors, no questions asked, and then come in at the end and say, oh, by the way, those doors you sent us, which you no longer get to look at or test or do anything with, we don't have them, but we're going to charge you for them. What it does is it prevents companies from laying in the weeds. If you take the UCC argument in the revoke, if you read it literally, what it says is typically, if there's a revocation, it has to be a latent defect. And then that latent defect has to be proven by the person submitting the latent defect. We submit that at the time that they took the doors back, agreed to replace them, and made no, hey, we're taking back under reservation rights or any of that, and send you new doors, we've proven the defect, at a minimum.
How's that? I mean, how's that under the code? I don't see, it seems to me the code doesn't have anything language like that.
Well, let me put it to you this way, Your Honor. If we came in and let's say we did all kinds of testing and conclusively proved to ourselves, who did we have to conclusively presume to? The person who we're sending the doors back. We marked the doors, sent the doors back, they accepted them, they kept them as their own, they took them, and then they sent replacement products simultaneously with it, and never even said these doors were not defective.
Until later.
Until a trial.
But I thought they refused, I thought they sent you a bill, which they wouldn't have done if they had accepted those doors as defective.
Another good point, Your Honor. If you refer to the testimony of Bob Terhune, the standard course of business practice for this particular company is they build everything that goes out. Regardless of whether it's defective, if you're later to receive a credit, if you're later to do anything, they build everything that goes out to you. So, in this case, there was approximately 120 doors that went out. Several were sent back, they didn't dispute. Then we've got a remaining 30 that's at issue. Every one of those got billed. It was at the end when they started applying credits some 4 months later after the doors had been disposed of that they said, oh, by the way, you got to pay for these other doors. That's a little unfair.
But didn't the trial court make a determination that your client had not met their burden of proving a defect, and in fact, that the problems with the doors were caused by the manner in which they were stored?
And Your Honor, we would submit that the trial court shouldn't even got there. The reason why is because the persons that sold us the doors agreed to accept them back. And if you...
But isn't that a disputed issue of fact? I mean, isn't there I'm quite certain that,
no,
that we'll hear from Coastal Door that they accepted the doors back as defective.
No, Your Honor, they never said they accepted them back as defective. If you refer back to the
But
testimony...
yet you're trying to say that they did. That the fact that they accepted them back establishes proves your case, proves the fact that they were non-conforming. That's the logic I don't follow.
Okay. What we're saying is, at the time that... You can look at it two ways. Way number one is under the UCC, if a person converts, a purchaser, buyer, purchases a product and makes it his own, he then has the ability or the inability to establish whether or not the product is defective. Well, first he can reject and then he can revoke based on the ability or inability to prove a defect in that product or a non-conforming product. That's his shot. What we're saying is that we don't even get to that because they just agreed to take the doors back. They didn't say, well, we're going to dispute this, we're going to review this, let's see what happens here. They just took the doors back, and they took them to their own possession. So then the same converse should apply to them. If they took the doors back and used them as their own, which they did, we never got them back, never saw them back, and never even heard word that they were defective or not until the day of trial, then the same should apply to them.
So you're saying that through the course of discovery, the fact that these doors were not defective was never raised, and through discovery, the fact that you didn't know until literally you went into trial that they were taking the position that the doors were stored in a way that caused them to delaminate?
Oh, no, Your Honor. In that that's the misconception from the lower court. The way the doors were stored as far as delamination, what's telling is go back to the testimony of Bob Terhune and Shane Davis. What would happen in the ordinary course of business, there was two ways that Coastal did business typically when it came to disputed product. Way number one was somebody says we've got a problem with the product, which it happened in this case as well. In this case, Coastal also provided the windows to every one of the project, every window hole in the project. Our guy said, hey, we've got a problem with these windows. They're not going up right, they're not going down right, something like that. What did Coastal do? They sent a representative out and said, hey, it looks like you're the guys that did something wrong here. And they worked it out. My guy wrote a check for $114,000, no questions asked. Again, it's the same sell of good, incorporation in. So then at that point it's deemed acceptance. If we follow the appellee's performance, they pointed out the problem to us, and we said, okay, we'll fix it. And then comes the doors. We've got a problem with the doors, and we've got defective doors. The instructions from them were to remove the doors and mark the defective areas, and we pick them up. That never changed. Never changed through the entire course of business. And at that,
you're saying that act establishes that they have accepted the return of the doors and an admission that they were defective.
well,
There's a presumption.
yes, at that point they take the doors back into their possession, but it even went one step further. They did take the doors back into their possession and never said that the doors were not defective. In fact, when I asked David Miller on the stand, have you ever communicated to anybody that these doors were not defective in your opinion? No, I have not. And in reasoning on that, we look at the Bloom case, which is a Southern District of New York case, but it's also the same sort of logic that's applied in the Hackett-Lloyd case, is once there's a failure to afford a reasonable notice of a discovered defect, it boils down to notice. You've got to give the other party notice of what's going on. And that's what the UCC is designed to do as we work in the ordinary course of business. And I'm getting into my rebuttal time, and I'll step down.
May it please the court. Mr. Taylor, my name is Todd Harris, law firm of McDonald, Fleming, Moorhead, here on behalf of the appellee, Coastal Door Window. I think for purposes of our argument, it might be helpful to the court to begin with a brief factual, very brief factual overview. What are at issue, in this case, 30 interior doors. They were ordered by the buyer. They were delivered to the buyer by the seller. They were sanded, painted, and hung by the buyer. The buyer installed these doors in a beachside condo that was not fully enclosed and did not have an air conditioning system. The installation, the trial court found, was a violation of established industry standards. The doors began to delaminate, at which time the buyer ordered 30 additional doors, which were delivered by the seller. It is uncontroverted.
Well, it seems to me the buyer has a different take on the facts, because as I heard what Mr. Taylor said, was that they complained about the problem with the doors, and they didn't order 30 new doors, but Coastal Door elected to replace the doors. Which set of facts is correct, or are we talking about disputed facts here that the trial court made the determination?
I believe we're talking about disputed facts, which the trial court made a determination, and having read the appellate's brief in this case, I don't believe that they appealed those findings by the trial court. The trial court found that the 30 delaminating doors were discarded by the buyer in this case and were treated as job site wastage, which under Chapter 713.01 subsection 13 means they are deemed to have been incorporated into the improvements on the real property. That was the finding of the trial court. In its multiple page order. Part of what the trial court sets forth is that the doors were stacked up, piled up. It notes Mr. Bob Terhun's testimony that the doors were treated by the buyer as, quote, beyond any sense of salvage. So those were the findings by the trial court. I don't believe that those factual findings or the legal finding there has really been appealed in this case. And that's a key finding because the entirety of the appellant's argument in this case rests upon an incorrect assertion. And that incorrect assertion is that it was undisputed before the trial court that these doors were rejected by the buyer and returned to the seller. That is simply inaccurate. As the court knows, in Chapter 762, the UCC sets forth specific requirements for a buyer to follow if it wants to reject a purchased good. Similarly, as I believe the court's already noted, if the buyer accepts a good and later discovers a latent defect, there is a provision for how the buyer may then revoke its acceptance. The burden is on the buyer to establish the existence of a latent defect. The buyer, in this case, as the court found, did not establish the existence of a latent defect.
What's your view of the issue that was framed by the pleadings upon which the case was tried? Issue or issues?
The issues before the court at trial were foreclosure of a construction lien under Chapter 713, Florida statutes. Also pled before the court was a breach of contract by the buyer and a breach of guarantee by Mr. Tagg, who is the principal of the buyer. The affirmative defenses that were raised, as I understand it, before the trial court, were that they believed the doors were defective in some way, and therefore they were not obligated to pay for these additional doors. Of course, that was the central matter, is whether they were obligated to pay for the 30 doors that were delivered.
I guess the breach of contract theory from your side was simply based upon non-payment for goods that were delivered.
That's correct, yes, sir. It's important to point out in the trial court's order, which begins on in Volume 4, page 666 of the record, the trial court makes specific findings of acceptance, and that's at page 667 of the record. The trial court finds that the 30 doors were not defective, but rather damaged by the buyer's neglect. Therefore, the buyer could not carry its burden of showing a latent defect sufficient to allow revocation of the acceptance. And that's pages 668 through 670 of Volume 4. Further, here's part of the key. This is page 678, Volume 4, that the 30 doors were not returned to the seller, but were treated as job site waste by the buyer, were discarded, and deemed as a matter of law to be incorporated into the property. I would submit to the court that these findings by the trial court have not been challenged by the appellant. Instead, the appellants incorrectly state that it was undisputed that the doors were rejected by the buyer, and then move forward based on that erroneous premise to argue that the trial court failed to apply the appropriate law in this instance, based on several types of duties that the appellant claims the trial court should have inferred from the UCC. The first of those duties that the...
Isn't that what he's really saying is that there was nothing from Mr. Terhune, the former employee, nothing from Mr. Terhune to indicate that he disagreed that the doors were defective or not suitable, coupled with, and now this wasn't part of an argument, but I think it would be mentioned, coupled with the fact that the doors, once they were picked up, were gone, and he didn't have any further ability at that point to demonstrate defect because he relied upon what Terhune said.
Well, of course, what the appellant is arguing is, you're referring to the duty to protest argument, as I'll call it, which they base on the Florida Statute 671-207 is what they argued in their brief to the court, provides this so-called duty. If the trial court had found a rejection to have occurred in this case, That statute still doesn't impose a duty on the seller to protest that rejection or forever waive its right to damages.
Counsel, I asked the appellant this question, and I'll ask you. Was the duty of protest argument or issue raised before the trial judge?
No, sir, it was not. It was not raised for the trial court. I don't believe even implicitly raised before the trial court. The plain language of the statute itself doesn't lend itself to that interpretation. The appellants have cited no case law to this court supporting this so-called duty to protest. In fact, as we point out in our brief to the court, the comments to the statute, the UCC comments to the statute state just the opposite of the interpretation that the appellants would have you adopt. The comments to the statute state, in relevant part, that the statute, quote, is not addressed to the creation or loss of remedies. And quote, it does not add any new requirement of language of reservation, or not already required by law. And finally, that quote, it does not affect or impair the provisions of this act, i.e. the UCC. Another important point, I believe, is that there's no evidence in the record to indicate that at the time these doors were discarded, there was an actual dispute between the parties. The record reflects that the dispute arose when the buyer refused to pay for the doors. At that point, the transaction was at an end, except for the payment. So even if this court were to adopt the appellant's requested interpretation of the statute for duty to protest, even under their interpretation, it wouldn't apply.
So the doors had been discarded before there was any knowledge of what's the period of time between the time the doors were picked up and the time that your client realized that the appellants were refusing to pay?
Well, I think you have stages of that. First, you have monthly invoices going out in which you can have non-payment on an invoice, and then it goes a couple more months, and it goes a couple more months. And I would say that we get up to our demand letter almost a year later, and in the filing of suit in the action. So certainly 30 days after the invoice, that's when the non-payment, I guess, begins. But even under their interpretation, there's nothing in that statute, either plain language or the lack of any case law, really, that would support this so-called duty to protest under the UCC. And as Judge Norwood pointed out, the trial court couldn't have even addressed that issue because it wasn't raised before the court.
Does this record reflect at any point when these invoices at the price of those doors on them that there was any protest from the buyer of the doors that the invoice was incorrect or that the products were returned as defective?
The invoices themselves that don't indicate any protest from the buyer regarding the price of the doors.
The question was, does the record reflect any protest, not on the face of the invoice, but in response to the invoice?
In response to the invoice, Judge, I don't recall anything in direct response to the invoice. I believe what we have.
The appellant argued that, well, they always invoice for everything and then adjust it. Does the record reflect adjustments or requests for adjustments on these doors at any point?
I believe that some of the invoices that are in the record, Judge, reflect a complaint by the appellant that the doors may have been defective, but I'm going from memory on that.
But didn't the appellant's representative make some communication with Coastal Door that we've got a problem with these doors? Otherwise, you wouldn't have known to bring in new doors, right?
Oh,
Sure. They claimed that their doors were delaminated.
Sure. When I say there wasn't a dispute, I don't mean to imply that the appellants didn't indicate that they weren't happy with with something with the doors. But what the trial court found was that when they removed these doors, what they were doing was discarding the doors as job site wastage. The trial court did not find, in fact, it's just the opposite, that they rejected the doors or revoked acceptance of the doors. And that's what's key under the UCC. We have a specific statutory framework for how these disputes can be resolved, and it's one of the clearest frameworks I think that we have in statutory law. So the idea that there's a duty to notify, I think, is not supported by any legal argument. It certainly wasn't argued to the trial court.
Did spoliation come up at trial?
No. Spoliation, if you ever...
It came up in appeal.
It came up in the appeal, Judge, but it was yet another issue that wasn't raised at trial, and a review of the trial transcript will reveal that the word is never mentioned before the trial court. There was never any claim of that, and certainly never any pleading or motion raised to that effect. In the last couple of minutes that I have, there's a couple of other issues that they raised. One is the admissibility of the expert testimony in this case. There was no expert testimony submitted by the appellants in this case to support their claim that the doors were defective. The appellees, the seller, provided two expert witnesses. The appellants argue that the standard of review for this court as to whether that testimony should have been admitted is de novo. That is not the correct standard of review in this type of expert witness, because this wasn't a Fry objection or anything having to do with the Fry standard. The proper review is abuse of discretion.
What was the objection that they raised at trial?
The objection that they raised at trial was that Mr. George Atkinson had not physically viewed the doors, which he was testifying about, and therefore wasn't qualified to give his
That's
expert
not
opinion.
really, I mean, with all due respect, that's not really an opinion objection. That's a predicate / relevance objection is what it is. And I was concerned that it was phrased in the brief as an expert. It's not, in my opinion, it's not really an expert opinion issue. The issue is whether the proper predicate was laid, which is that the witness had knowledge of the facts that he's testifying.
And of course, it's the discretion of the trial court as to what weight or credibility he will give the witness testimony. So, the proper standard of review is abuse of discretion on those issues, and for the reasons I raised in our answer brief, the trial court was proper in allowing that expert testimony, both from Mr. Atkinson and Mr. Dave Miller, who is cumulative in his testimony, and his testimony is not being challenged before you today. So, for the reasons stated in our brief and presented before you today, we request that the trial court's judgment be affirmed.
Here's the problem we're faced. We're faced with climbing a mountain and giving no boost to climbing. They took the doors back on this by us saying that they're defective, and then we get to trial and they want us to put on expert evidence as to them being defective. We can't do it. That's the reason why the UCC is designed to work the way it's supposed to. And I'll address the first argument that 671.207 does not apply to a seller. And 671.207 refers to a party. It doesn't refer to a buyer or a seller. It refers to a party. And the comment section that the Appellate Counsel referred to actually has to do with accord satisfaction. What the Florida Court said is we're not dealing with an accord satisfaction issue under the UCC. It's not a waiver, vice versa. And there's scatterments all over the UCC. So what Florida said is we're not creating a new right or a new cause of action by including or not referring to this language. And then if you look at the Marsh case, in the Marsh case, it's kind of the situation we have here. It's a Texas case that basically holds when a buyer gives something to the seller then returns it, and the buyer keeps it and retains possession of it as if it's their own, there's no further rights owed by the buyer down below. So what that means is once they sold the windows to us, we we picked up the window, or excuse me, the doors. Once we picked up the doors, put the doors in, hung them, said we've got a problem with it. They said, take them down, we'll pick them up. That's what we did. They retained possession and control, and then they asked us or tell us that we have to prove that the doors are defective at trial. And there are notes made on the invoices where our guy complained that these doors are defective. They were on notice that we've said, hey, these doors are defective. Nobody came to us and said, you know what, those doors are not defective. And as to the expert witness testimony, you're right, it's sort of a mixed issue. We're saying that the application of pretty much an application of the expert's testimony to the law is not applicable.
Refresh my memory, are the Texas cases you cited UCC cases?
One is not. It's not a UCC case because this typically doesn't happen under the UCC. It's not a UCC case. It's actually just a standard Texas law case. Yes. However, if you refer to the Happy Court or the Bloom case, both of them are talking about notices back and forth. You've got to give notice as you're doing business on the ground, ordinary course of business. And I'm out of time.
Thank you very much. That concludes our cases for the week. So we enjoyed the meeting in Pensacola. We lost most of our audience, but thank you gentlemen very much for being here. Good future.
Hopefully this is proceeding your way, right? It might be remanded. Is that really what you want to say?
Actually, what we're really doing is
What is the number one?